Welcome to Partnered Up Business Law, Deals, and Dynamics.
Welcome back to Partnered Up Business Law, Deals, and Dynamics with Jeffrey and Fink, partner at Coren Lichtenstein LLP in Massachusetts. Jeff advises business owners and partners on formation, growth, and dispute resolution for closely held companies. I'm Evan Mack, and today we're talking about deadlock clauses and what really happens when business partners can't agree on anything. Jeffrey, sir, welcome back.
Hey, Evan, how you doing?
I'm well. Jeff, can you give us an example of a deadlock in a closely held business? Are there some kind of decisions that tend to trigger deadlock more than others?
So deadlock usually comes up around questions about the future. Fighting over the sale of a business happens a lot. Do we sell? Do we not sell? I had a client who spent well over $1 million in legal fees trying to resolve that one. Strategy issues, and one of the things that comes up there, I mean, sometimes it's just operational strategy, but really it's arguments, or not arguments, they're concerns over income or the sale of the business, and how do you manage it? Or, are you managing it just to get the money out on a daily basis? Or are you managing it toward an ultimate sale? It's usually about money, but with control issues kind of in the background. But it can be anything. Deadlock mostly comes up with businesses that have operations rather than just financial investments. Other partnerships may have their issues, but they're structured differently, so it comes out differently. And sometimes deadlock happens just because people don't like each other anymore.
So how do most partners expect disagreements to get resolved when they're setting up a business?
They don't think about it. And they'll just assuming that everything will be great going forward. And when it's not, they haven't had some of the hard conversations they probably should have had. That happens a lot. Even when people do bring in lawyers, they'll pull operating agreement or shareholder agreement forms off the internet. Most boilerplate contracts are either silent about deadlock or just have a boilerplate provision on it that may or may not work for people. They don't think it through. They haven't. Nobody's made them sit down and ask these questions, and sometimes people don't even know what questions to ask.
So what are some examples of how deadlock clauses, work at a high level when partners reach that impasse that you're talking about?
So I'll give you 4 examples. First one is mediation. A lot of contracts want people to bring in a third-party mediator or a facilitator of some sort to help smooth things over. And sometimes it works, sometimes it doesn't. Sometimes it's a step toward whatever the next phase of the deadlock clause is. And it's actually called a step clause. Mediation never hurts because nobody's bound to it. There's just the cost of the mediator and the cost of thinking about it in advance. Sometimes you'll have a tiebreaker, whether it's some third party who can come in and say, this is what you should do, or one of the members has kind of a super voting right if there is a deadlock. The tiebreaker provision, well, we'll talk about tiebreaker provisions a little more later on, but sometimes they work, sometimes they don't. Sometimes you'll see a mandatory sale to a third party. Basically, if somebody wants out, they can force a sale. That works okay if you have kind of a defined asset within the business. You own a piece of real estate, for example. If you don't want to run it anymore, and one partner wants out, you can say, let's put it up for sale. Then, of course, people can always try to negotiate with each other to buy it out. The last one, which everybody hates, except that nobody can think of a better way to do it. It's called a Texas shootout. You want out, you have to propose a price, and either you buy or sell at that price, depending on what it is the other person wants to do. So you're saying, I want out, or I don't want to work with you anymore. So I'm giving you the option: do you want to buy me out, or do you want to sell to me? And so that puts a lot of pressure on both parties. Um, may or may not be the best way to do things. There are variations of that where you're required to, both parties can put in a single bid to some third party who then opens it up and says, "Yep, you're the higher one. You get to buy, or you have to sell." Um, but there's unfortunately there's no one right way to do things with a deadlock clause, and um, nobody really likes them when they get triggered.
So where do you often see this deadlock fall short? Can you walk us through a situation where that deadlock clause kind of existed on paper, but the business still ended up being stuck?
That's a great question. So, had one situation with it was a joint venture, a couple of companies who were involved, and they had a tiebreaker come in with a decision, and one of the uh, one of the partners, members, JV participants, was happier with the result, uh, but the other was so unhappy that it kind of killed cooperation between the two of them. And these two companies that owned the joint venture, it was running a separate little business, but they had done some business with each other in addition, kind of outside of this, and it affected that as well. So it was all well intentioned. Technically, it solved that problem, but it created a lot more. Another situation involved, it took a couple of steps to get there, but it required a sale to third parties or to a third party. So they hired somebody to sell the company because they had to. And one of the partners didn't like that concept. And even though he was not supposed to do this, he messed with the process by calling all the likely prospective buyers and said, "Don't bid on this. Don't bid on this. I'm going to get this. I'm going to win it. You don't want to be my enemy." And so they backed off. Um, it ended up coming back to bite him because it depressed the price, and the other partner bought him out at a lower price than he would have gotten if he had sold to a third party. And actually, that was kind of a sad situation because it turns out that the irrational behavior he had was caused by kind of early stage dementia, and
Mm,
went downhill pretty fast from there. But
wow.
people do that even if they don't have those issues. But yeah, that cost him.
So Joe, we talk about it in previous episodes about how emotions dictate things, but how do those and personal dynamics between partners go along with that rational thinking and greed to affect whether a deadlock mechanism actually works?
Yeah, I mean, you can't discount greed. And you can't discount real rational decision making over what's best for you, what's best for the company. People are making personal decisions. If their company is involved in some kind of joint venture, they're making business decisions for that make sense for them. But a lot of our decisions aren't rational as much as we want them to be. So if people feel that the decisions are bad for the business and bad for them, then all of these factors are factors. They just are. If people don't trust or just don't like their partners anymore, it's going to be a problem. If you have a mediator or tiebreaker or arbitrator for that matter, and if people don't trust them, it's going to be a problem. You know, the anthropologists say that one of the things that keeps a legal system afloat or any system of rules afloat is that people trust in the process to be fair. And when they're dealing with these deadlock provisions or deadlock mechanisms, sometimes people don't think it's fair, and so that reduces their faith in the whole process. And kind of the last big thing that we do see is like in that example I mentioned a few minutes ago. If people feel like they can game the system and they feel like they have the motivation to do it, it may not work. May not work.
So when there isn't a workable deadlock provision, what paths tend to open up, and which ones create the most damage in your opinion?
Another great question, Evan. Um, talk is cheap. Literally,
Mm,
negotiated outcome is going to be way, way, way cheaper than anything else that you can do. If you go into anything that involves a court, it's going to ratchet up the cost, and you have to be willing to be on the litigation merry-go-round. You need that sometimes. If the parties won't talk to each other, if they won't engage, if there's just a wildly divergent view of what the right outcome is, then you may need a court to step in. Once you do that, though, you have to be concerned about possible personal claims and counterclaims and all that, just because lawyers like to have fun. The other thing, and this is it's an interesting situation. The leading case on this nationally is from Massachusetts. Concept of manufactured deadlock. I just want out. How do I get out? And so you claim there's a deadlock. You do all kinds of things that make it look like a deadlock, but it's not real. And you do that in order to convince a court, yeah, there's a deadlock, you should dissolve this. And the case law lists a whole bunch of factors that the court should look at about whether it's a real deadlock or whether it's a fake deadlock. We've researched it. We've never been able to find a case where the court said anything other than just cite those factors and decide there's a deadlock. So with judicial dissolution, it's not supposed to be a no-fault divorce, but it effectively is. Another thing is there's a possibility of withdrawal or termination or repurchase, depending on what the documents stop you from doing, or what they say. There's like a statutory right to withdraw from an LLC in Massachusetts and under certain circumstances and get paid out a certain amount. The last answer is you just live with it and move on.
All right.
And might be a good decision.
Yeah. But so Jeff, for businesses that want to reduce the risk of getting completely stuck, what kinds of conversations are worth having early before these disagreements start to happen and start to harden?
Same kind of stuff. Who owns the business? Who gets the money on the sale of the business, which is kind of the same thing? Who gets the money while the business is running? Control stuff. If you're dealing with a business that has individuals involved, you do need to think about the 3Ds and the R: death, disability, divorce, and retirement, and how that's going to affect business and ownership. Do you want an org chart to start off and talk about who runs what, and who does what, who has oversight? Sometimes I will work with people kind of to come up with a responsibility checklist of who's doing what. Titles are important, and sometimes they signal control stuff. Sometimes they signal other things, but it's worth thinking about that up front. And then you have to ask the question: is it worth the money to develop and document all this stuff that may stop deadlock? Is it worth thinking about what kind of deadlock resolution clause you might want that's right for you? I would almost always say yes. I have a bias, just because I see things that work and I see things that don't work, and the ones that don't work. So, so I would say, yeah, talk to somebody about it up front and get some advice about what's right for you.
Amazing. Jeff, appreciate your time, sir.
Thank you. Have a great day.
You too. And that's it for today's episode of Partnered Up, Business Law and Deals and Dynamics. To learn more about Jeff Fink and his work with the business owners and partners at Coren Lichtenstein LLP, visit cl-lawgroup.com. Thanks for listening, and be sure to leave a review, and subscribe to the show so you do not miss the next episode. Thank you so much. We'll see you next time.
See ya.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.